Good afternoon. Welcome to the Cato Institute. I'm Clark Neely, Senior Vice President for Legal Studies. With me is my friend Rachel Barkow, who is a professor of criminal law at New York University and has also served on the U.S. Sentencing Commission and was most famously the so-called counter clerk for Justice Scalia, meaning the clerk to sort of push back and test his premises, right?
Well, in theory.
In theory, all right. So we're here today. I'm very excited to talk with Rachel about her new book, Justice Abandoned. And I'm particularly excited about the fact that in the acknowledgments, Rachel notes that the genesis of the book came from her Simon lecture that she delivered here in, I think it was 2021, right? Which we do on Constitution Day. Every year on Constitution Day, September 17th, we put on a full program, and then the capstone of that is bringing in someone to deliver our Simon lecture. And so that was Rachel in 2021, and that was the genesis of the book. Is that a true story?
That is a true story.
That's awesome. Yeah. I appreciate that. So I was trying to figure out how to characterize the book, which I love, by the way, fantastic book, and see if this works for you. Metaphorically speaking, I consider this book to be a bunker buster for the following reason. You state a fairly narrow and extremely provocative premise, which on its surface seems so controversial that one doubts that the author could really defend it. And then you essentially drop the book like a piece of ordnance through multiple layers of seemingly impenetrable rhetorical concrete, and then you just annihilate any opposition, in my opinion. It's not possible, I think, to, in good faith, refute the basic thesis of this book. And I will tell you, I was a little surprised that two things. I was surprised that anybody could pull it off, but if anybody could, it would be you. And you get to the end of the book, and I don't know how you could fail to be persuaded. And the thesis, and I want you to push back if I don't get it right, or elaborate if I do. As I understand the thesis of the book, it's this. You and I both believe that we do have a problem with mass incarceration in this country, and yet reasonable people can differ about the socially optimal amount and mix of incarceration, whether you should be mostly drug dealers or mostly whatever, right? But what reasonable people should not be able to disagree about is that the pursuit of one's vision of socially optimal incarceration must take place within the constitutional constraints that are part of our founding document, right? And as I understand it, the thesis of the book is that essentially the government hacked those constitutional constraints in key ways so that it is able to achieve a higher level of incarceration than would be possible if those constitutional limits on government power were being enforced.
Exactly.
Okay.
That's exactly right.
Are we done? No, we're okay. So, you wrote the book, so just why don't you riff on that, and then I'll have some sort of specific questions.
Sure. So thanks for everybody who's paying any attention to this. I appreciate it. So I am very interested in how America became a country that, depending upon which statistics you look at, but most often is listed as the most carceral country on earth, and why we're so punitive. And for the most part, my research has focused on political dynamics, historical, cultural things, and that was the focus of my last book, and that's a lot of what I write about, just institutional incentives and how we end up where we are. But in the course of writing that last book, and just kind of thinking about how we are, every now and then it would pop up, it would be like, yeah, and of course, we could always try to go to the courts to challenge certain things, because there's this provision of the Constitution that says, you can't have cruel and unusual punishment, or, there's due process. And then I'd kind of run into the fact that the Supreme Court had decided cases that somehow nullified those protections. And basically, by the time I'd finished my last book and I gave the lecture here, I thought, I really don't think people have paid enough attention to the Supreme Court's role in allowing mass incarceration in America to take place. And so I just decided I wanted to explore that. And then in terms of the format, I had a list of cases in mind or topics in mind that I knew were a key part of it. So one of them is plea bargaining, because you just can't get that many people in prison unless you can process cases on an assembly line kind of a a way, and plea bargaining is the engine that drives all that. So I knew I wanted to talk about that, and I knew I wanted to talk about the case where the court is confronted with these egregious facts. Prosecutor says to this guy who writes a check he forges a check for $88.30 to buy some groceries, and prosecutor's like, he's facing 2 to 10 years under the statute. Prosecutor's like, okay, you plead guilty, it's 5 years. And the guy's like, I don't want to plead guilty. And the prosecutor says, if you put me through the inconvenience of a trial, then I'm going to supersede your indictment, and I'm going to charge you with this habitual offender law, and it's a mandatory life sentence if you're convicted for an $88.30 check. And so I knew I wanted to talk about that case and how the court approached it and why it was so wrong, and have the facts. And as I started thinking about it, I thought, there's a lot of cases like that where the court was faced with this really important fork in the road where it could enforce the Constitution and put limits on a really bad governmental practice, but it chose to just defer to the government. And that's kind of how I got the idea that, okay, you know what, there's a group of cases I know I want to talk about, and then there were a couple that I had to kind of think hard about which case. Like with policing, there's a range of choices of what you could talk about.
A plethora, one might say.
Yes, there's no shortage. So I spent some time reading cases and figuring out which one I wanted and I thought was the most important. But that was the way the book was born. And I thought one of the reasons why the cases and talking about them is helpful, they're really interesting. The facts, I think, of these cases are accessible to lawyers and non-lawyers. And I give you the legal framework that you would need to kind of analyze the case after I tell you about it, so you'd see where the court got it wrong. And that was basically what I decided I wanted to do. And as I was writing it, I saw all the connections between the cases and how they work together in these really awful ways. And by the end, I definitely had convinced myself, I will say, by the end, I was blaming the Supreme Court on a regular basis, like how'd they get us into this mess?
Yeah, so a few points. First of all, I want to do a little housekeeping. We will take questions and answers after we've had our discussion. We'll do that both from the audience here, and thank you, by the way, for being here, and also for those online. You mentioned plea bargaining. We're going to get into that, obviously. For those who don't know, saying plea bargaining around me is like saying to Captain Ahab that you'd like to talk about white whales. I'm always up for it. But a couple points that we should maybe explore and maybe just sort of do a top-down look at the book so everybody's on the same page. First of all, what you're really arguing in the book is that there were specific Supreme Court decisions that not only could have come out differently, but should have come out differently. And had those come out differently, the amount of incarceration that we have just would not be possible. That's point one, right?
Yes.
And these cases were not only demonstrably erroneous, let's not say demonstrably, but there's an even more powerful point you make, is that according to the interpretive framework that is favored currently by the Supreme Court, mainly original, if you had done anything remotely originalist in these cases, they would have come out the other way.
Yes.
And this to me was the really sinister point that should keep people up at night. These cases were not only independently erroneous, they operate synergistically so that the error is magnified by the way they interact and reinforce one another. Is that a fair point?
Yeah, that's all true.
Okay, so let's talk about, let's just tell the audience kind of what are the main areas that you look at in the book. And it's pretty manageable because there's 6, right?
Yeah.
And just by way of introduction, one way to think of it is, think about the process of essentially pulling somebody into the criminal justice system and then processing them through it, right? So there's the initial contact with the police, and you identify a problem there, right? If they decide to proceed with the prosecution, there'll be the question of whether they can lock you up pre-trial. That turns out to be a really big deal for a couple of reasons, including the fact that people's lives start to fall apart when they can't, go to their job or pay their bills, et cetera. And also it's really difficult to participate in your defense when you're in jail. So there's the pretrial detention. There's the question of what it takes to obtain a conviction, of course. You've already touched on that, plea bargaining. And I thought one of the most fascinating things is the case law that essentially further empowers prosecutors in terms of the magnitude of the threat that they can. So you'll talk about that. And then there's the question of, once you convict somebody and decide to imprison them, right, that's costly, or it ought to be costly because you have to pay to operate a prison system, but there's ways you can cut corners on those costs, aren't there? Yeah. Right. So feel free to jump in anywhere along the line. I know you take it in a different order in the book, so you feel free to just start out wherever you want in terms of elaborating on any of these.
Yeah, so we could start with pretrial detention because I think, particularly given everything that's going on in the news these days when we're thinking about what does due process mean before you lock somebody up, how do we think about that? So For our entire country's history, we're like a kind of good 200-year run, there was consensus that you could not detain somebody just because you arrested them. That is just not how any of this works. You are presumed innocent. There is a presumption of innocence. And what due process means is if you want to lock somebody up because of a criminal offense, you have to go through a trial and the government has to prove guilt beyond a reasonable doubt. Everybody agreed that was the case. And the only way you could detain somebody was because they were a flight risk. So you just might need to detain them so the trial could take place. So if they were a flight risk or they posed a risk to a witness, then you could detain them for those reasons, but not because you thought they themselves were dangerous. There's a separate process for that. You have to go through civil commitment. It couldn't be through the criminal process. And that was a consensus in this country until the end of the 1960s. Okay, so at the end of the 1960s, and I'll just kind of give you this vignette because I think it's good, emblematic of the other cases. So Richard Nixon, he's running for president, and it's a contentious election, and it'll come up in more than one case because this is going to be an important moment for all of them. And he's running on a law and order platform, and he's running against the Supreme Court because the Supreme Court had decided Mapp versus Ohio, which is the case that said if you get evidence in an unconstitutional manner, you can't use it in somebody's case. It creates this exclusionary rule, and it's hugely unpopular, right? Because you might have people who did heinous things that go free because there's this evidence that can't be introduced. So the public hates it. And the Supreme Court had also decided Miranda, which gives people warnings before they're interrogated. Hugely unpopular, that too. So there's signs across America that say things like, impeach Earl Warren, down with the court in the 1968 election. And Nixon is running on this idea that he's going to combat crime. All right, so there's two cases in the book flow directly from that election. So one of them is Terry versus Ohio, which is the policing case, and it's decided in 1968. And 1968 is just a bonkers year in American history. Like, for anyone who just wants to read a really interesting year, you've got major assassinations, you have protests and riots all across the country, including here in DC. So while the Supreme Court is deciding this Terry versus Ohio case, I talked to one of the law clerks who clerked at the court at the time, and he was disagreeing with me when I said, Terry, you can't justify Terry based on any constitutional methodology. He said, you know what you don't understand? He said, if you looked out the Supreme Court windows, you would see DC was on fire, literally on fire. There was smoke. And he's like, it was just chaos and protests and riots.
I was born in 1968. I'm not asserting any connection, but...
It's quite a year, yeah. And so, so his point was, if you just really understood how afraid members of the country were in 1968, you would kind of understand what happened. So one thing that happens is the court, they're running around with these impeach Earl Warren signs. So one case, they just get this Terry versus Ohio case, and that's the case that says that the police can stop you and frisk you for weapons even if they don't have probable cause. And that's another thing, by the way, for 200 years, no one thought that was a thing. Like, nobody thought that was possible because the Constitution is really clear. And I should just say, when I say that these cases are wrong, I understand people can disagree about constitutional methodologies and how you do it. These are wrong under any major constitutional methodology. That was my criteria. So you can't justify them as a matter of text. You can't justify them as a matter of original meaning. You can't justify them as a matter of the precedent that came before them. They are just these weird things that prop up that are based on nothing but pragmatism.
No, there's one other thing, actually. I made a note of this. Conservatives tend to ground their jurisprudence in originalism, textualism, whatever it might be. I would say that you've made a very strong case that the jurisprudence of criminal law from a conservative standpoint, it's all based on their feels. I feel that police should not be liable for violating people's rights and they need protection. There you get qualified immunity, right? I feel that it's scary that we would release somebody who's been arrested and charged with a violent crime. Do you think it's an exaggeration, or is this really,
Unfortunately, no. I think it's, I think public safety gets people to want to turn constitutional corners in ways that I think are they're hugely problematic, obviously. And it wasn't like, the framers of our country knew that people panicked about crime and safety. So the Constitution, if you just read it, you'll notice it's really preoccupied with provisions that apply to criminal cases. They kind of had the idea that you could get a tyrannical government that would stamp over people in the name of panic and fear over crime. And you need a court to enforce that, though, for it to work. And 1968 was not a good year for that because basically the Terry versus Ohio case comes to the court. There's an officer in Cleveland who, Officer McFadden, and he normally his beat was pickpockets and shoplifters, but he sees on this public sidewalk in Cleveland, he notices 2 African-American men walking up and back on the sidewalk. And then what really gets his suspicion is a third man walks up to them, and that third man is white. And now Officer McFadden is like lost his mind, and so at that point, that's when he stops. So they've walked up and back 3 times, and it's 2 black men talking with 1 white man. That's the basis on which he stops them.
Wow.
So now, if you were thinking to yourself, is that probable cause that a crime has been committed? I hope your answer would be, oh my gosh, no, that's like not even close. But he does stop them, he frisks them, and at that point, by the way, they did have weapons, so whatever his intuitive sense was, and so they're charged. But the question is, was that a lawful stop? Was that a lawful pat down or search of them? And it would need to be probable cause. But when the case gets to the court in 1968, the court has these signs. I think they're thinking, you can tell from reading the justices' papers that they feel like they have to give the police a win. And by the way, they know that this kind of stopping people on the basis of suspicion is being done in disproportionate ways. It's definitely targeting people of color. There's briefs filed in the court that basically say, want to know one of the reasons why people are protesting and why cities are experiencing this? It's because communities of color are over-policed in these really harassing ways, and this would make everything worse. So the court knows all this. They still decide they're going to vote for the police. So they take their initial vote, and they decide, we're going to uphold this. And they try to write the opinion saying there was probable cause, because they know that's the standard. That's the actual standard that they need. There's a draft opinion, it's terrible. And it circulates to the other justices, and they're like, oh man, we can't issue that. So they start searching for a theory, how could they uphold this? So they're doing exactly the opposite thing you'd like a court to do, right? What you'd like a court to do is look at the Constitution and say, what does the Constitution require? Is that met here? My job is done. Instead, they start with, we have to find a way to let the police do this. How could we kind of create a provision or reread the Constitution to reason backwards and to let it happen? And that's how they come up with this kind of ability to stop someone on the basis of reasonable suspicion. They literally invented out of thin air. And every legal historian that's looked at this has said this is absolutely not consistent with the Constitution's original meaning. So that's kind of one case to give you a flavor. The other is, again, so it's 1968, Nixon wins, and he decides that he needs to get tough on crime, but it's actually pretty hard for a president to do that, right? The federal government doesn't police crime in your neighborhoods yet anyway. And so he decides, what could I do to show I'm being tough on crime? And he decides, I could focus on DC, and he has a member of his legal team and his administration, a man by the name of William Rehnquist, who's going to later become the Chief Justice. He has him help draft a law for DC that will allow you, after you arrest people, to detain them pre-trial, just on the basis of their arrest. All right, so this is novel, and everybody recognizes, even in the Nixon administration, that they're pushing the envelope. I kind of liken it to today, if the current administration wants to claim an end to birthright citizenship, you'd be pushing a well-established envelope that everybody recognizes is constitutionally, it's acceptable. You can't do it under text, originalism, meaning, but you want to kind of try, how could you find a way to do it? So the way they do it is they get this DC law, they write it, and the DC law is narrow because they know they're pushing the envelope. And it's basically, as long as the government could show there's a substantial probability that you committed the crime. If it could be shown that you presented danger, you could be detained up to 60 days. Okay, that's the DC law. And the Attorney General of the United States writes a law review article, which I just think is hysterical, that was also part of the strategy. So he himself, you will know later on in Watergate, will find himself charged and convicted of a crime. But at this point, he's focused on putting people away behind bars. And he writes this law review article trying to justify why it's okay, in spite of the presumption of innocence, to lock somebody up just because they were arrested. And it's a terrible law review article. I recognize law review articles are not that exciting for most people, But even by law review standards, it's just really shoddily argued, and it's not convincing. And it gets decimated in a reply by Larry Tribe, this preeminent constitutional law scholar at the time, writes a reply. And just shows this is just completely wrong. And not only is it wrong as a matter of constitutional law, but this will be the end to liberty as we know it in America, basically. Like this will not be limited. Mitchell says in the article, this is going to be a teeny tiny exception. Maybe 10% of cases will involve people being locked up. We're just doing this little tiny thing. So that law ends up getting upheld in D.C. courts here, and it ultimately becomes the basis for other states passing similar laws and the federal government doing the same thing. So, all this is coming from the Nixon idea. And there's a federal bail reform law that allows for pretrial detention, just after someone's been arrested. It doesn't have the 60-day limit. There's no time limit anymore. It doesn't have any requirement that you show there's a substantial probability that the crime occurred. In fact, it creates presumptions of detention for certain things, including if you're charged with a drug offense, as long as there's a statutory maximum of at least 10 years, which is basically every federal drug law, you're presumed dangerous, and you're presumed to have to be locked up. So that's the law that goes before the Supreme Court, where the Supreme Court has to decide, can we lock people up who are presumed innocent just on the basis of their arrest? And the opinion is written by, I can guess, it's written by Bill Rehnquist, because now he's the Chief Justice at this point. So, this was his brainchild from the beginning. So maybe it's not surprising that he ultimately writes the opinion. And, he basically just says, the presumption of innocence really doesn't have anything to do with this. This is just regulatory. This is just locking people up as a safety measure. It's like a regulatory matter. The Eighth Amendment and the excessive bail clause, that doesn't have anything to do with this either. And it's, the whole analysis of everything, it's a very short opinion. And it's basically just, we're allowed to do this because the government gets to stop dangers. And the government, when they argued that this was okay, the Solicitor General's brief, the chief case they cite that says the government can prevent, dangerous things from happening, the chief case they cite is Korematsu, which some of you might know is the case that allowed the detention of people of Japanese descent that has been, disavowed by our current court as an abomination in our constitutional history. And yet, it's cited in the brief, it's the leading case cited by the Solicitor General. And the court itself doesn't cite it in Salerno, but it uses all the logic from it and says, yeah, we can do this. So, those two cases give you kind of a flavor for the court basically assuming as a matter of public safety, we need to give the government certain tools. We need to let them stop people even if they don't have probable cause, and we need to let them detain people if they just are, they think they're dangerous. Let's just trust the government to do that. And after those two things happen, what they thought were going to be minor, and I'm from New York. They, at its peak, they were stopping and searching almost 1 million people in a year on the basis of stop and frisk. And in terms of detention, 75% of the federal population of people who are arrested are detained before their trial at this point. So we went from maybe it'll be a narrow exception to people questioning when you don't detain people pre-trial. And the other cases are like that. The other cases have that same kind of feel where it's not like you look at the text or the history and you say, yeah, this is okay. The court never even bothers doing those things. And it's for good reason. If they had, they couldn't have come out the way that they did.
So one thing I remember making a note of in your book was that various assurances were given when Congress was considering, essentially whether to implement this pretrial detention policy. And in the book, you say that many members of the Senate that passed the Bail Reform Act seemed unaware that detention could last longer than 90 days. For example, Senator Strom Thurmond erroneously said 90 days is the worst case limit. And then you drop this bomb in the next paragraph. The average period of pretrial detention for federal defendants is 255 days, and there are some districts where it's more than 400 days. Yeah. And so there were these assurances that were given, right? And they were completely off. Do you think that was just, were those assurances made in good faith, but with inadequate sort of thought and information, or do you think they may have been made in bad faith?
I mean, I can't say they were made in bad faith. I don't have any evidence.
But they just misunderstood what they were doing, that fundamental.
They definitely misunderstood what they were doing. I think they thought, anyone who practices knows that the Speedy Trial Act is not really going to be your friend and help you, and they sort of assumed it might. And I think, they may have thought that it would be narrow. I'm not really sure. I find it hard to believe that they could have thought it would really be at 10%. Because once you start doing things like creating a presumption for drug offenders, you kind of have to know that it's going to become more sweeping. But there are cases. There's a case. This person was held. So he's arrested. And he's held pretrial, and they don't have space for him in the regular jail, so they put him on the death row because they have extra space on the death row. So he's being detained. Remember, he's presumed innocent. He's put on death row, and while he's there, and he's there for almost 4 years waiting for his trial. And people next to him they got executed. The person in the got executed. So he files a cert petition to the court, basically saying, "Is this what you meant?" So even if they didn't know it at the time, they are getting cases where the person is saying, "I've been held pretrial for almost 4 years on a death row. Is that okay?" And, the court doesn't even take up the case, which, you can draw the inference that it is okay then, because they don't find the need to intervene and stop it. So I think whatever might have been the original understandings of everybody, certainly now no one could claim that they don't understand the consequences of what happened.
And the case we're talking about here with pretrial detention is Salerno.
Yes,
right?
yes.
So in the margin notes I have here on your discussion, I have sleazy DOJ litigation gamesmanship, and I would be remiss if I didn't give you an opportunity to tell. So Salerno is not only a bad decision on the merits, the way it got to the court wasn't very savory, was it?
Oh no, it says, and I have to admit, when you were saying the case book goes in a different order, so I start with Salerno because I so enjoyed learning about the background facts of this case that I thought this is the best case to start the book with. So Salerno is the case where the government decides this is the case we should bring up to get the Supreme Court to say pretrial detention is okay. Because remember, for 200 years, everybody thought, of course it's not okay. And even though these lower courts and statutes were getting passed, the Supreme Court had never said it was okay. So you want a good test case, right? You want a case that's going to kind of make the court feel comfortable. So the case the government brings involves Anthony Salerno, who is otherwise known as Fat Tony. He is the head of the Genovese crime family.
No, he's a Simpsons character. Oh, he's both. All right.
Right, before he was the Simpsons character, he was the head of the Genovese crime family. So, no, that's pretty good, right? Because if you're thinking, like, what's the kind of person you might want to detain pre-trial, it might be the head of one of the, major crime families, because otherwise he's going to be out there ordering hits on people and doing who knows what else. And one of his lieutenants, this guy, Fish Califano. Okay, so there are these two mob guys, and the government says, this is who we're detaining under the Federal Bail Act, right? As opposed to what the typical case would be, which is like, some drug offender. But they get these two mob guys. What they don't tell the court, okay, so they say, like, hey, we have to hold them pre-trial. What they don't tell the court is that, so after the court had granted cert in the case, Fat Tony had been tried, convicted, and sentenced in another case, not the one that he was being held pretrial, but in another matter, and he'd been sentenced to 100 years. And the way sentencing works is that he should start serving that sentence immediately, even while his appeal is pending, if he's dangerous. And remember, the government is saying he's dangerous because that's why he needs to be held pretrial. But in his sentencing, they go to the trial judge and they say, "Judge, don't sentence him yet. Don't sentence him yet. Keep him pre-trial." And the judge is like, "Oh, okay, right." I think everybody kind of understands.
Literally to keep the case alive.
Just to keep the case alive in the Supreme Court. But that's not even the worst set of facts, because I think the worst set of facts is Fish, yes, his lieutenant. So there, the government, after they file the petition, but before cert is granted, the government decides to sign him up as a cooperator. So they want him out and about wearing a wire and getting evidence on other people. So he's not even in pretrial detention anymore. He's out. He's out on a bond, and he's gathering evidence on other people. And the only thing the government says is, yeah, he had to be released for medical reasons, but he's still subject to pretrial detention. So neither one of them presented an actual live case. And, in one of the dissents says, this is really unseemly. This, seems really improper. But it did not stop a majority from going along with the case and ruling on the facts.
Okay, so we can think of pretrial detention as the appetizer. Let's get to the entree.
Okay.
And for me, I found that the most, sort of arresting part of the book was the way in which you showed that two seemingly discrete Supreme Court decisions do in fact operate synergistically to sort of, intensify opportunities for mass incarceration. And it's the Bordenkircher plea bargaining case that you've already talked about, and then essentially the abandonment of proportionate sentencing. So do you agree that those are very synergistic? And if so, run with that.
Yeah, no, absolutely. So if you think about, and this may not have happened to any of you or people you care about, and I hope for your sake it hasn't, but if you know of anybody who's had any kind of involvement with our criminal legal process, basically what happens is you're charged with something, and at some point, you're going to have a discussion with the prosecutor, and they'll offer something if you plead guilty. And it's like the facts of that case that I told you about Bordenkircher, where, he's offered, if he pleads guilty, 5 years, but if he goes to trial, he faces this mandatory life sentence. And it may not always be as egregious as that, but it is pretty typical that you would be facing significantly greater sentencing risk if you go to trial. In the federal system, it's 3 times greater, your sentence after you go to trial, than if you plead guilty. So it is a huge penalty if you exercise your right, and you have a right in our Constitution to a jury to hear your case if you face a sentence greater than 6 months. So, that is in there, and you have the right to do it. But what prosecutors are doing is they're putting a price tag on that right that is so heavy that even if you were innocent, you'd have to think twice about whether or not you want to take your chances, right? Like if even if an innocent person, you might think to yourself, who innocent would ever not go to trial? And then you have to just realize that, think of the risk they're running. If what you're being threatened with is you plead guilty and maybe you'll get time served. And time served, by the way, because you're in pretrial detention. So they're really synergistic because you're probably detained pretrial and you want to get out. And what if the government says to you, time served, all the time you've put it in jail, that'll be good enough for us if you just plead guilty. Or, I'll offer you this deal with only a little bit more time. But if you go to trial, you're looking at 10 years, 20 years, 30 years, 40 years. You'll never see your children again. Your elderly parents, they'll die before you get out. People make decisions where they decide to plead guilty even when they're innocent. We know that because we know from exonerations on DNA evidence that 10% of the people who've been exonerated with scientific DNA, so that's going to be a low number, were innocent, but they still pleaded guilty because of this bargain that they were engaged in.
And those tend not to be crummy little drug crimes. Those tend to be like rapes and murders.
Yes.
Right? So people are pleading guilty to that kind of thing.
Right. Horrible reputational things, but and they know they're innocent because they are, but they're afraid, right? Because you don't know, juries aren't perfect, and you don't know exactly what evidence the government has. You don't know how it's all going to shake out, and it's a risk, right? You really have to worry. And
frankly, you don't even know if the government's going to play it straight at trial.
Correct. And so the key thing about that is that, so you might say, well, but what's the government threatening you with exactly? What can they threaten you with? They can threaten you with any crime that they have probable cause to believe that you've committed. And the Supreme Court has no proportionality review to kind of say, well, but let's make sure that the sentence for that is proportionate to what it was. So if we go back to the Bordenkircher versus Hayes case, Mr. Hayes, so he writes this check for $88.30. I don't think any rational individual would say that even with his past record, he had some petty offenses and he had a sex offense when he was a juvenile that, he was only in a reformatory for, not even prison time, that he should get a life sentence, right, for the $88.30. And in fact, his prosecutor didn't think he should, right? His prosecutor thought he should get 5 years. So how could you give somebody 100 years? If we had a functioning Supreme Court, they would look at our Eighth Amendment and they would say, that is a cruel and unusual punishment for a check in the amount of $88.30. But the way these cases are synergistic and the way Clark mentioned is that we have really no cap on what the government can threaten in terms of that other sentence. So as long as there's probable cause to charge the person with the habitual offender law or whatever it is, there's not going to be an independent inquiry to say, yes, but did the legislature put a punishment attached to that offense that's too great, or it's too great in your case? There's really no review for that. The Supreme Court has just decided that's too hard. They don't want to be involved in proportionality review, even though that is absolutely what our Eighth Amendment requires. It's what it means. There's a long-standing English tradition about, you can go back and you can see cruel has more L's and unusual, has a fancy S, but it's the same language, and you'll see every time it appears, it means disproportionate sentences. And the court, though, has come up with this precursor, initial hurdle test to get to that evaluation that no one can pass. So they don't review any of these. And what it means is then in the plea bargaining relationship that defendants have with the government can say, oh, you don't like my deal? Well, then I'm gonna bring this additional charge, or I'm gonna charge it at the beginning and I won't dismiss it unless, you agree to plea. And you could be looking at a differential as great as the one that Hayes faced. It's 5 years or it's life. It's 50 years or it's 2. And people plead guilty under those circumstances because honestly, wouldn't you? I mean, it's too great.
Yeah, and to the extent people might try to poo-poo this by saying, well, Bordenkircher was 50 years old and it's not a thing anymore. For those who may recall, do you remember the Varsity Blues prosecution? These were about 50, Hollywood celebrities, Wall Street bankers and so forth, who did a variety of things to get their kids into preferred schools, including, for some reason, University of Southern California, no offense. But that ranged all the way from some really gross stuff like hiring somebody to take the SAT for your kid. Fair enough, that's fraud. But all the way to just cutting an unusually large check to the sailing team, right? Do you remember what the standard plea offer was to people in those cases about what people were serving? A couple months.
Yeah.
The U.S. attorney in Boston specifically told defendants through counsel that if they didn't take the offer, whatever it was, that they would go back and re-indict them and add a conspiracy to commit fraud charge for which the exposure would be 20 years. So that happens to this day.
Yeah.
Right? And it's standard. What is I think the last year for which we have reliable data, 98.3% of all federal criminal convictions came from guilty pleas.
Yeah, so it's just
so
the
we're closing
norm.
in on 100%.
Yeah, it's the norm, and you might ask yourself, wow, don't people want a jury trial? Like it's in there, that's what you get, and this is why you don't really see jury trials in America, because if you want to exercise that constitutional right, the government is going to put such a huge price tag on it that you can't, you really can't take the risk. And, I should just point out, and the book goes into greater detail, but there's a whole doctrine called the unconstitutional conditions doctrine that says you can't do that to constitutional rights. You just can't. And you might, well, how did this...
Unless it's the right to trial.
Right. The Supreme Court, though, just will not analyze the jury trial right as it does other constitutional rights. It just has decided to cabin it off with really no rationale in the opinion. It just says, well, but that's the give and take of plea bargaining. It's just the give and take, and so allows it to happen, which, isn't great constitutional analysis. I don't think you have to go to law school to recognize, like, is there a give and take exception to the Constitution?
Yeah.
And, there isn't. And the result is, the thing about all these cases, and I'm sure this all sounds weird where people are like, what's wrong with you? Of course we do plea bargaining. Of course we detain people pre-trial. Of course we have long sentences. All this seems totally normal and like commonplace now, but it hasn't always been like this in our country. Like, these are really the last 50 years. These are innovations that the government just kept pushing the envelope, and the court said yes. And now it seems commonplace, and now it seems okay, but only because the Supreme Court didn't hold the constitutional line. And so, it's the difficulty is, can you kind of undo, can you put the genie back in the bottle or whatever metaphor you want after you've already done it? So
I could talk about coercive plea bargaining all day, as you know. We're not going to. But I want to move us to the part of the book that in some ways I found the most raw and vivid for me. And I'm going to move us there by talking about something that as a constitutional litigator was the bane of my existence, which is reflexive judicial deference to other branches. And I marked a couple places in the book where you refer to the amount of deference in this area as pathological, and you characterize it as unquestioning. And you make a really interesting point in the chapter about prison overcrowding, that the Supreme Court exhibits essentially boundless deference to the basically decisions of other branches about the conditions in which people can be confined. But then you make a really interesting point about why it is so kind of insane to have judicial deference as to those kinds of decisions. You know what I'm talking about?
Yeah.
So elaborate on that, because it's such a powerful point that you've got the judiciary deferring to decisions that, as you were about to explain, you shouldn't. Right. However you feel about the relationship between judges and the other branches.
Yeah, so I should just say, this is another thing that, I think people just assume, well, of course prison conditions are awful and they're crowded, and, if ever I write anything in public spaces, the commentary is always, well, then they shouldn't have done the crime, right? They did this to themselves. themselves, whatever squalid, awful conditions. That's actually not the framework in the Constitution. There's a requirement that punishments not be cruel and unusual. So there's a bare minimum that you have to provide people if the government is going to take them out of free society. You have to provide medical treatment. And there's certain things you have to do, including provide a sufficient amount of space so that they don't suffer mental and physical health consequences. Now, if you say, so normally if we think, okay, deference, the police say they need this for public safety, there is nobody who comes before the court and says, we have found that what is important for us in our prisons is to only give people the space the size of a door. And that the case where the court was deciding whether the conditions were too crowded, that was the amount of living space that the person had, about the size of the average household door. And they were in that space, that was their portion of the cell, and they were in that space all but 6 to 8 hours a week. That's where they lived. And that wasn't because corrections officials said, we've calculated it, and this is exactly where we need to place people. In fact, they did just the opposite. They built that facility for one person per cell, and they did it based on studies and psychological studies of what the bare minimum space was for a human being, not to go through mental deterioration. The Army followed the same metrics. Everybody agreed, that you needed somewhere between 50 and 60 square feet for a single person. But what ended up happening, and what happened all over the country, was that because there's no cap on the sentence length, because plea bargaining is run amok, is we start to incarcerate people way faster than we're building prisons. And so what starts to happen is there's no place to put all these people, and no one's thinking about it because there's no kind of centralized authority. They're just coming into your system. So if you're running a correctional facility, they just come into, it's time to admit them, and you got to find a space for them. So you're just shoving people into whatever spaces that you have. So it's not like you're deferring to them because they thought that is ideal. In fact, it's just the opposite. No one's been thinking about this. And the problem is that your legislative branch, your state legislature, or our Congress, they're just not appropriating enough money, or they're not planning well enough to create enough facilities for us to be able to do that. And by the way, that's happening right now with immigration facilities. If you're wondering one of the reasons why people are being shipped to other countries into horrific conditions, we don't have enough space because people aren't planning. They're not thinking about where you're going to put people and how you're going to do it. And that has been the case with our prisons. So when the Supreme Court decide, and that's true of all prison conditions basically, because they tend to be, if there's not enough space, if they're in disrepair, their heating and air conditioning breaks, none of that is because corrections officials are like, what would be great? Let's put everybody in small, because that's also a workplace. That's also the workplace for all the corrections officers. Like, that's not an environment that anybody wants to be in, and it's not safe, and it's not good for people to be in environments like that when they come back out, because this creates an environment where people are going to be prone to violence, quick-tempered. A lot of people come in with mental health issues that are exacerbated. All this is like not how you'd run an ideal correction system. But if it's not funded and you have nowhere else to put them, you're just jamming people into this. And the Supreme Court, when the case finally gets to them, it's the first case where they're deciding about overcrowding. And at that point, we'd had a lot of lower courts in the United States where judges had ruled that prisons were in violation of the Eighth Amendment. And it's interesting because these weren't like liberal judges, some were, but a lot of these were just very traditional conservative judges all across the political spectrum. But they would go visit these prisons and they would immediately see these are unconstitutional conditions. And so judges around the country were striking down sentences in those, or mandating that the prisons change various aspects of them. The case that I write about in the book is the first case that the Supreme Court gets that's really like a conditions overcrowding case. And basically the opinion is written in such a way that it stops those cases from succeeding even in the lower courts afterwards, because the language the court uses is basically so dismissive of successfully challenging conditions cases that afterwards, lower courts get the message. They get the message because they say things like, who are we to second guess these legislative and expert judgments, which are not that. They're just not paying money. But it really does kill that. And, the way I characterize it in the book is it's like giving a 2-for-1 sale on the Constitution, right? If there's a certain minimal amount that you have to provide in order for the state to take away your liberty, And the court essentially says, okay, well, you can put 2 people in that space or 3 people in that space, right? It's like a half-off sale. Like all of a sudden now you don't need to provide the constitutional requirement. You get like 2 for 1, 3 for 1. And it is not a coincidence that we see after that case, then everybody realizes, oh my gosh, all bets are off. And they do nothing to try to control overcrowding at that point. So it's also a driver of mass incarceration, even though intuitively it might require an extra step to think of how it's related.
Yeah, so we'll take questions in a few minutes. I want to do 2 things before we turn to them. First, I don't know if there's any room for optimism here or a sliver of sunshine, but if there is, you should talk about it. But I want to make a point that I raised with you, when you and I were going back and forth about this, and this is something also that's kind of been the bane of my existence as a constitutional litigator, which is it's incredible how successful the government has been at putting citizens on the wrong side of what's called the Socrates paradox. So this is the idea, the problem of the heap. Imagine a single grain of rice. Is that a heap of rice? No, right? What about 2 grains of rice? Heap of rice? No. Now, you get to 100,000 grains of rice, it's a heap. But if you can't say the exact particular grain of rice that turned it, from just a little pile to a heap, then you lose. And think about that in the prison overcrowding situation. So you imagine a prison cell is designed for 1 person. They're putting 2 people in there. And you're going to get a judge to say, well, I don't run prisons. I don't know if that's too many. 3 people in there. Well, that does seem like a lot. But again, who am I to say that 3 is too many? And it just, at a certain point, obviously, it's too many people. But a judge can always say, well, I don't know where it clearly crosses that line. And we see this, I think, over and over again. We see it with how much pressure prosecutors can apply in plea bargaining. We see it with how many years they can threaten you with, right? We see it with the square footage or how many people share a toilet in prison, that the court can always just kind of say, well, I'm sure there are limits, but who am I to say that they've been reached in this case? Does that strike you as a fair characterization?
Yeah, no, that's a really, really great way to put it too, because I think it's a combination in these cases of the court really worried about public safety and not wanting to kind of stand in the way of what the government claims it needs to protect all of us. And the combination factor is, how could we administer this in a way that wouldn't give lower courts too much discretion? I think if they thought they could get every case and they could police it, maybe it would be different. But, this is going to be, judges around the country are going to have to do it. And they're very uncomfortable giving those judges that power. And the fact that you can't draw a bright line to say, well, it's 5 years and no more, and exactly the way you're talking about, has made them uncomfortable. And I get it. Like, this is not an area where you can come up with really great bright line rules. But I will just say, in other constitutional, the constitutional context, the court has had that same problem, and it still polices things. So the kind of example that I think is most on point with, say, sentence lengths is punitive damages. Mm-hmm. So if you have a corporation and there's a punitive damage award against them for engaging in some kind of tortious or improper conduct, the Supreme Court has said, yeah, we're going to review that. Oh my gosh, we're going to review that, because sometimes too much is too much for these corporations. And, even though line drawing is hard, we're going to have some benchmark standards and we're going to take a look. And I think there is no justification for the court being willing to say, yes, we're going to do it when it's a corporation and they're facing a damage award.
Rachel, it's not just any corporation. That was BMW being exploited by the state of Alabama. It's not like that was a mere human being, right?
It's the ultimate driving machine. But that you wouldn't also say, when it's an individual's liberty at stake, we're going to do the same thing. And in fact, they could actually even use the same kind of test and framework, as I point out. So although I'm sympathetic to the fact that the line drawing isn't easy, that's just the nature of our Constitution. There are just some constitutional provisions are easier than others to create bright lines with. And the ones that aren't, it's the court's job to offer guidance and for them to trust lower courts to kind of not go too far. And I don't think that they would, by the way. I think we would be able to get administrable standards that would be okay. But the court has been unwilling to do that. And I think in part these cases and the people involved in these cases, I think to the majority of these justices, seem like others that they're just less concerned about. And I think that's created a cognitive space that has made them less concerned. I'd be curious how many of the justices have visited prisons personally, or have had representation of individual clients themselves, like regular people who've been either prosecuted or sued by the government. I think it changes your perspective when you've had those experiences, and I don't think many of the justices have. But I did want to be more optimistic.
Well, can I
Yeah.
just,
Oh,
I'm going to give you that transition.
Okay.
But I want to quote something from the book, because it's, I think, maybe my favorite single sentence. And I think it really nicely pulls all of this together. You make, I think, a very powerful point. You say the Constitution does not prioritize some vague feeling of community safety over the tangible liberty interests of the accused. That's really the essence of it, isn't it?
It is it's for me, but I don't just get that out of nowhere. I mean, I think that is our Constitution's founding principle. That's why you have a Constitution, because honestly, if you could just trust the majority to kind of get things right, you don't need a document to rein in the government.
But if that were the animating spirit of the case law, things would look totally different, wouldn't they?
Yes.
And could it be? Are we, like, is that over the horizon?
Okay, so this won't be super optimistic, but it'll be somewhat less grim than what I've explained.
We'll take anything at this
Yeah,
point.
so I think, so the other reason that I wrote the book the way that I did is there's other cases I don't love in the criminal law space. But I had a criteria for these cases that if you were someone who cared about original meaning, these cases are terrible, right? They don't stand up to an original meaning analysis. And, that was intentional because I do think that's a dominant methodology on the court, and I think it's one that the justices, many of them, take very seriously. So I also think this book is an interesting opportunity for the justices because you had mentioned earlier, so, I clerked for Justice Scalia, and I myself am not a Republican, and he knew that. And he hired me anyways, much to his great credit, I'll say, or at least to my benefit. And one of the things, so I heard him give a lot of speeches while I was a law clerk. And, one of the things he liked to do when he would give his speeches is he'd say, I'm an originalist, and he's like, but that doesn't mean I always get the results I want. And he would always talk about the flag burning case as his example where, he said that it violated the First Amendment to prosecute people for burning the flag.
Texas v. Johnson.
Yes, and he would say, I had to go home to Mrs. Scalia after, casting that vote. And, Mrs. Scalia would look at me and say, the flag, and it, though, when he would give the speech, people would be like, that's a man of principle, though. That's a man of principle because even though, he did not want that outcome and, Mrs. Scalia didn't want that outcome, that's not the kind of people they are. They're very anti-flag burning people. He stuck to his constitutional guns. And I think he liked the example because it would allow him to say, I'm not just voting results. This current court, I don't know that many of them have a flag burning case, on the speaker docket if they wanted to go out. But I present to them the cases that they could go out and say, you know what, I believe in originalism, and I also, this is a court that is willing to overturn precedent, longstanding precedent. So, obviously they overturned Roe versus Wade, a 50-year-old case in Dobbs because the court said, hey, in their view, it was egregiously wrong. And these cases are egregiously wrong, and they don't comport with original meaning. And so they are perfect cases for the court to do one of two things. Either they can, in fact, overrule them, and then they can go out, and this is their flag-burning case, and they can say, hey, look, this is the methodology I follow, and I follow wherever it leads. And sometimes it leads me to conservative results, politically conservative results, but sometimes it leads to results like these, but I still do it because I'm a principled judicial actor. So they could do that. Or if, people start to bring up these cases or try to get them on the court's radar and the court doesn't do that, I think there's value in that for the rest of us to then say, hey, well, wait a minute. Then, you're a hypocrite. You're not consistent. So I think they're good cases to put the court to the test. I mean, I'm actually somewhat optimistic about some of the justices. I think Justice Gorsuch has been very good in criminal cases. Like, I think that he has stuck to originalist guns in contexts that make me think he would, if given the opportunity, rethink some of these.
We actually had a question online about Justice Jackson, who's the only justice with public defender background. Yeah. She was an appellate defender. But she and Justice Gorsuch have an interesting dyad that they show up together on these issues, right?
They do, and it's not perfect consistency.
No.
But
it's the Supreme Court.
Yeah, exactly. But they do, and I think I think it's not coincidental. I think he is a pretty consistent libertarian in his outlook, and that he has that libertarian outlook that I think was similar to the framing generations, and it really does manifest in these cases in ways that I think he'd be sympathetic to, and I think she would very much understand. She herself has said, she also believes in original methodology, so I think, she would understand the originalist argument for these cases, and she would certainly understand the stakes for the individuals. So, I think Justice Sotomayor is someone else who has really a lot of experience as a state prosecutor. You can kind of get to 5 if you hope for the best and think about how different outcomes could come up. I mean, some of these cases I think may be more palatable than others for them to reconsider, but it would require people starting to try to push the envelope, and I hope that they do.
So I've taken one online question. That's all I'm going to do. Let's do a couple of rapid fire questions here. By the way, do you know what Justice Jackson wrote her senior thesis on at Harvard?
I do, because I read it.
Yeah, me too.
Yeah.
I highlighted it.
Yeah.
It was plea bargaining. All right, so audience questions. State your affiliation if you're willing, and please keep it really short, and Rachel will keep her answer really short, and we should be able to get 2 or 3 before we have to wrap up. So, anybody? Okay, Jay.
Jay Schweikert, former Rachel Barkow student. Thank you. So I guess my kind of larger question, you touched on this a little bit with the discussion of 1968 and why that was such a crazy year for the court to be deciding these cases. To what extent, after looking at all these, did you feel like these Supreme Court decisions were upstream versus downstream of the forces of mass incarceration? Or in other words, in which of these cases, if the court had had both the courage and the integrity to stick to an original understanding, could it have really shifted these practices, or were these, and does that difference, does it vary by different area of law? Are some things, were you left the sense that some of these changes were kind of coming through one way or another and the court might not have been able to stop it? Or could some of them have really gone a completely different way if the court had stuck to its guns?
Yeah, no, it's a good question. And I should just clarify, these aren't all 1968 cases. It's just that 1968 happened to be the year that Terry was decided and the beginning of the pretrial detention stuff. But that case came in 1984. Some of the others are in the 1980s. But
can we just leave 1968 alone?
Yeah, okay.
Let's take it.
But I mean, you raise a good question about, are the forces so powerful that whatever the court did, somehow it could still take place? And as I said, that was kind of that's usually what I write about, is these political forces are just really powerful. But I don't think we could reach the scope of what we had if the court held its guns in any of these cases. But some are more important than others. So I do think, plea bargaining is going to happen whether the court says it's okay or not, because that's a practice. Although, I said things like we never detain people. No one thought you could detain somebody on the basis of dangerous. People also didn't think you could plea bargain, but that is something they did all the time. From basically the beginning of our country's history, they were kind of, they had a clear dockets, and so they would come up with arrangements. So I think something like that, if the court had said, well, there's terms of plea bargaining you can't have, or it can't be coercive, I think we'd still have it, but we wouldn't have it to the same extent. And so I think what it would mean is you would have more trials, and it would give defendants more leverage when they are having discussions, because that ability to go to trial would actually be real. So, I think that would result in some reduction. I think if the court had said you need to have, the one that I think would make a big difference, if you really had to stick to a minimum amount of space that you had to give a particular person. So that I'll say is the contrast to plea bargaining, which I think is still happening. It would just be reduced. If there's a prison space requirement, that would have really significant effects, because that's money. And jurisdictions at that point would have to decide, now what do we do? And the reason why I think that would actually matter is, I talk about this in the book. So California got to the point. So after the Supreme Court decides Rhodes versus Chapman, they're going insane around the country in overcrowding, including in California. But California reaches the point, and you can see pictures online, and I encourage you to look at them, because they're triple bunking people in gymnasium spaces. It's insane. And that leads to people dying, deaths by suicide, medical conditions going untreated. It's horrible. So bad that at a certain point, they decide you have to release almost 40,000 people from the California prisons in order for them to no longer be a threat to the health and safety of people. And the Supreme Court upholds that 5-4 in that case. It's called Brown versus Plata. after the court decides that case, so this is like a little microcosm of how I think it would have worked if the court had really, done this on a broader scale. California was like, oh man, 40,000 people, like, what do we do? So they don't go build 40,000 new prison beds. They have to figure out how to get 40,000 people out of there. And so they do this thing called realignment, where they basically start sending people back to local communities and say, here, like, if you think they need to be in your local jails, you take them. But, they can't be our state problem anymore because we don't have space for them. Anyways, with realignment, what ends up happening in California is people go free. And the court, I should say, the dissenters in that case were like, this is going to be, blood is going to be on the majority's hands. Time will tell how awful this will be. Time has told, it was fine. Because basically what it allowed was some rational reflection of who needs to be in and who doesn't. And so I think, so when after realignment, there was a minor uptick in property offenses that then went immediately down. And so there was no increase in crime and 40,000 people were out. So I think that's an example of something that if the court had really said, look, there's just a minimum amount of space, what jurisdictions would have to do at that point is start figuring out how do you control the inflow into your prisons so that you don't exceed your capacity, which means you'd have to start thinking who really needs to be in there and who could we deal with in other ways. And that's the kind of rational reflection that I would hope we would all want, but they don't do now because it's just too cheap to be lazy. So I think some yes, some no.
Yeah, we're out of time, unfortunately. Rachel's going to stay, so you can ask your questions for her lunch. I think I'm going to pull it together and say it this way. I believe, so obtaining a criminal conviction is costly. You have to be willing to spend money on the resources, and people have to take time off from work to serve on a jury, et cetera. Incarcerating people is costly, right? You have to provide the facilities, the guards, et cetera. So you might say that our carceral appetite is way up here. Our willingness to pay for it is down here. And the only way we get from here to here is by the Supreme Court enabling us to get both convictions and confinement for pennies on the constitutional dollar. Fair way to summarize?
Yes, absolutely.
Well, shame on us, right? And let's continue to try to work to fix that. Thank you. This book is a major step in that direction. I highly encourage it's for sale outside. Rachel will stay for lunch. We invite you to come upstairs and join us for lunch. Thank you so much for being here. I hope you've enjoyed our conversation.
Thank you so much. Thanks, Clark. Thank you.
Thank you.
Thank you.
Oh, that's great.